So I'm going to ask the first of the speakers to come forward. I think, Neil, you've been shown where you should be seating here and how to work the microphone. This is Mr. Neil Hind, who is the chairperson of the Pinewoods Conservation Group. And you've got 5 minutes to address us, Neil.
Thank you, Chair. Afternoon, everybody. I'm not just speaking for the Pinewoods Conservation Group, but also for Save Rotary Wood, Zero Carbon Harrogate, the Campaign to Protect Rural England, and over 1,000 residents and various other interested parties who have all objected to this application. I appreciate that's quite a long list. The applicant rests, as you've heard, on outline permission granted in 2017, a permission that came with clear environmental safeguards, especially Condition 12, which required a full ecological mitigation and management scheme to be approved before any detailed application could even be submitted. That condition was never met. When the current reserve matters application was validated in 2020, no ecological management plan was in place. It has also been suggested that the Council should have taken a full environmental impact assessment that was never done, maybe because of mistakes in the original application. This is still needed and could address the water extraction question that was raised earlier. The first genuine plan did not appear until last year, more than 7 years later. That means that this outline consent has expired in law. That is the legal view we've had. And the application stands before you on an invalid foundation. Condition 12 is not just a box to tick. It's a legal precondition. Approving a scheme without it not only undermines environmental policy, it exposes the Council to significant legal risk, including a judicial review. Members deserve a decision that will stand up in court, not one that will fail under challenge. You will also remember that Harrogate Council refused a larger site expansion on this same site a few years ago. That decision recognised the environmental harm, woodland loss and policy conflicts such an expansion would bring. Those same fundamental problems remain today. Approving this version now would overturn the decision without any new justifications. Even if Condition 12 was considered somehow live, the ecological evidence still fails that policy test. The Council's own ecologist confirms that the scheme does not achieve no net loss, let alone any net gain. To break even, the applicant has already said they would have to buy biodiversity credits off-site, meaning Harrogate loses its own valuable habitat value. This directly conflicts with Local Plan Policy NE3 and paragraph 180 of the National Planning Policy Framework. You have already heard that the new land being promised has no legal protection and is likely to be at risk from further extension of the site, further undermining any short-term ecological gain. The required Section 106 agreement that should secure these measures is still missing and was promised and assured it would be available before this meeting. Members are being asked to approve a development without seeing how biodiversity, woodland management or offsite credits will actually be done and how public access will be guaranteed to this new land. These vague promises are not planning control, only signed enforceable obligations are. Essential environmental evidence is also still missing. There is no lighting plan showing how the 7 species of bats recorded on site will be looked after. No updated noise survey for the new plant and the vehicle operation. Same goes for the highways changes that you've already heard about. These are all required under the Wildlife and Countryside Acts and habitat regulations to demonstrate that these protected species and nearby residents will not be harmed. Without that evidence, members cannot lawfully conclude that the impacts are acceptable. As we've heard, the site itself forms part of the Pinewoods Green Corridor, a valued space recognised as an asset of community value. It's a living woodland used daily for walking, education and well-being. This is not just a spare piece of land. Its loss would be permanent and contrary to both policies NE3 and HP1, which are there to protect green infrastructure and landscape character. So let's be clear here. Condition 12, never discharged, outline permission has lapsed. Any net biodiversity gain or even any quality of net biodiversity not achieved. Section 106, missing and currently unenforceable. Lighting and noise evidence, highways evidence, still absent. Community woodland will be permanently lost. The history that we've had, we know sites have already been rejected here. After 7 years, the facts remain the same. No lawful condition discharge, no completed 106, no adequate environmental evidence. You cannot protect biodiversity or public trust on missing documents. We therefore urge you to refuse this application, not because we oppose business, but because good business and good planning must follow the law. Thank you.
And thank you.